Thank you, and good afternoon. It's customary in New Zealand when giving speeches and addressing the court to commence with a few words in the language, the Māori language of our homeland. So, he aha, te mea nui te ao, he tangata, he tangata, he tangata. What is the most important thing? It is people, it is people, it is people. Out of respect to Māori, we have recently changed our rules of court, permitting the wearing of important Māori taonga or treasures when you're in court. So today I wear pounamu rather than the tie. Although I am Pakeha or European, I claim an important connection via my Māori grandchildren. I'm honoured to be here today as part of this panel to discuss such an interesting topic and to give a New Zealand perspective on how we think intersectionality has played a part in law reform, but also how we as the bodies representing the legal profession around the world can play a role. So the next slide. We have a strong history in New Zealand of promoting rights. We were, I'm going to be boastful now, we were the first country in the world to give women the vote in 1893. And on the screen you'll see the first photo is of Kate Sheppard, New Zealand's famous suffragette. The second photo is of Ethel Benjamin, who was admitted as barrister and solicitor in 1897, and she attended the University of Otago, which is in my hometown. The final photo is of Dame Georgina Te Huhu, the first Maori woman to gain a law degree, admitted in 1972 and then elected to Parliament in 1996. So I want to particularly focus on the benefits of law reform led and informed by women and those with lived experience. So we're going to talk about members' bills. In New Zealand, members of Parliament can introduce bills to achieve significant legislative reform. They are known to have achieved significant social change in New Zealand, so they are a particular way in which we see intersectionality and lived experience influence law reform. Members' bills are introduced by members who are not ministers. And on these occasions, the House hands over the power to progress policy to the backbenchers and the opposition parties. So some examples on the next slide. There have been so many pieces of law reform to choose from that it's difficult to pick those to talk about, but I'm going to very quickly run through a few. So, Marriage Amendment Bill by Louisa Wall, and this was about LGBTQI rights, and this allows same-sex marriages, and that was from 2013. The next one is Domestic Violence Victims Protection Bill in 2018. This introduced employment protections for victims of family violence, including a right for employees affected by family violence to request a short-term variation of working arrangements, a new entitlement to domestic violence leave, and amendments to the Human Rights Act to make it unlawful to treat an employee adversely on the grounds that they are affected by domestic violence. Then we have the Holidays Bereavement Leave for Miscarriage Amendment Bill. This was in 2021. This provides 3 days bereavement leave for mothers and their partners where a pregnancy has ended due to a miscarriage or stillbirth. And these rights include parents via adoption or surrogacy. We then have the Harmful Digital Communications Amendment Bill, enacted in 2022, and this bill created an offence of posting a digital communication that is an intimate visual recording of a victim where the victim has not consented. Then on to the evidence, I'll just call it the Evidence Amendment Bill, which was passed its final reading recently, and this bill aims to protect victims of family violence while giving evidence in court by allowing them to give evidence in different ways. For example, by a video recording made before the hearing, in the courtroom but unable to see one or more parties or witnesses, or from an appropriate place outside the courtroom, either in New Zealand or elsewhere. Then the final act, Improving Arrangements for Surrogacy Bill, which was originally a member's bill, which has then been accepted by the government. The aim being to streamline the surrogacy process in New Zealand. The Member of Parliament bringing this, he and his partner had a son via surrogacy in 2019, but when their baby was born, they couldn't legally take him home for a while due to the adoption process that is required. So moving on to the next slide, what we can do as champions. So it's critical that we represent and reflect the society that we live in. Traditionally in New Zealand, the profession has been dominated by white, middle-class, older men like me. A more diverse profession is one that better serves our communities and better protects the rights of the most vulnerable. By promoting diversity and rights, we are showing leadership not only within our profession, but within our society generally. I want to briefly touch on two important programs in the Law Society. Firstly, Women in the Law, and secondly, our role in championing our Indigenous people, the Maori, and their rights. So, on the subject of the Gender Equality Charter, this was a set of commitments aimed at improving the retention and advancement of women lawyers. For many years, 2/3 of law graduates have been women coming into the profession, and now they make up more than 50% of the profession. And there have been some notable achievements. I was conscious every couple of months I meet with the heads of bench in New Zealand, and that's the Chief Justice and the heads of the Court of Appeal and the High Court and other courts. And on this occasion I was there were 9 people in the room, and I realised I was the only man. Our Chief Justice is a woman, and her predecessor was a woman. So we have achieved a lot in certain areas, but across the profession at the higher levels we do not have women in those roles of power and influence. And so a lot of work is still needing to be done there. As I say, this is a very important program, and the Charter is... So by signing up to this, so law firms sign up to this Charter, and they agree to follow a set of ongoing commitments and to report to the Law Society every 2 years on what they are doing to meet those commitments. By signing up to the Charter, signatories commit to leading from the top, making a plan and taking action, and measuring progress. The specific commitments include tackling unconscious bias, encouraging flexible working, closing the gender pay gap, and promoting equitable instructions to counsel and arbitrators and mediators. The Charter is open to the whole legal profession. Law firms, in-house legal teams, sole practitioners and barristers' chambers can all sign up to signal their commitment to gender equality and inclusion. This is an important program, and it continues to be a work in progress. I don't want to suggest that we've already achieved equality at all levels. We must continue our work in this area. And something I'm conscious of too is that women in leadership and in the judicial leadership are also the subject of much more social media criticism than men in equivalent roles. Moving then on to Indigenous rights. So New Zealand's Indigenous people are the Maori. Before colonisation, they had a strong culture and a clearly defined legal system. Colonisation did what it did everywhere. It eroded well-being, rights, and destroyed a large part of the Indigenous culture and way of life. We are now seeing a resurgence of Maori culture, and we welcome that. And for an example, see how I started this speech. But it's important that we not fall into the trap of tokenism as well. The Law Society has put a lot of time and effort into the development of a Maori strategy that articulates our commitment to honouring the bicultural foundations of our country. This includes meeting our obligations as a modern regulator and representative body by reflecting Maori cultural values, equity and inclusion, and recognising the unique and enduring constitutional significance of Te Tiriti o Waitangi, the treaty. The treaty that is the founding document that was intended as a partnership between the Maori and the British Crown. Our strategy is a very practical document and speaks of what we want to be doing both internally and externally. So our logic is, as a profession, we have an obligation to uphold the rule of law. This means upholding our constitution. Our constitution is found in various documents, including the treaty. But when the treaty was signed, the Crown guaranteed property, it guaranteed customary law and their rights. That treaty was breached by the courts, by the Crown, it was breached flagrantly, it was breached consistently. It is our responsibility to do everything possible to redress those breaches. And as you'll see from those figures, 20% of our population is Maori, and our profession and our judiciary must reflect those numbers. Our relationships and connections are important to us, and we are actively looking for opportunities to work alongside our Maori partners to address challenges and deliver services to the profession and our wider society. One example that is particularly relevant is what we do in the law reform space. It's important that the stronger and bigger entity, namely the Law Society, makes room for the Indigenous voice. That we don't just speak for them, but champion them and resource them to speak for themselves. In the law reform area, we have a very close relationship with our Maori Law Society. We fund a staff member to enable them to make submissions on law reform. We share information with them and empower them to make the best possible submissions. We also take care not to undermine their work and to make sure we are not speaking at cross purposes. As part of our strategy, the Law Society has also issued guidance for all lawyers regarding its expectations as a regulator. The guidance focuses on the relevance of Maori customary law and Maori-related legal developments in meeting their competence and client service obligations under the professional standards rules. There was just one final matter I thought might be of interest, and as president of the Law Society, I sit on a steering group for a program of work called Te Ao Marama. Literally, this means the world of light, and signals a more enlightened approach to justice in the district court. This was conceived of by our own chief district court judge, Hemi Tomonu. He is a prominent Maori leader and a man deeply concerned about the failings of our justice system, particularly in its treatment of Maori. So Te Ao Marama is a judicially led district court program that partners with Indigenous tribes and communities to work with the court and justice sector agencies to ensure all court participants, including victims and family, can understand and better take part in the cases that relate to them. It is focused on family court care and protection, care of children and family violence cases, the youth court and the adult criminal jurisdiction. It's based on decades of evidence, reports and judicial advice that suggest changes and improvements in these areas to have the greatest impact. It is especially focused on supporting children and families who are at greatest risk when engaging with the family and criminal justice systems. Te Ao Marama has significant potential to reduce the number of children in care, the number of children who offend in the medium term, and the number of young people who enter the adult criminal jurisdiction in the longer term, all contributing to a long-term enduring reduction in offending and reoffending and the costs of crime. Te Ao Marama is inclusive of everyone, regardless of their ethnicity, culture, abilities, who they are and where they are from. It responds to repeated calls for transformative change over the past 4 decades and long-standing concerns expressed by victims, defendants, parties to proceedings and wider family members that they have found district court processes confusing, alienating, disempowering and re-traumatising. Te Ao Marama helps judicial officers and court staff to support victims in better ways For example, there are more opportunities for victims and their families to speak during the court process. Te Ao Marama partners with local Maori tribes and communities to design and deliver family wraparound service solutions to meet each community's diverse needs. By extraordinary coincidence, this program was brought into existence at the same time as my youngest granddaughter was born, and her name is also Te Ao Marama. She has breakfast with me every day, and her presence to me is a constant reminder that we need to move towards a more enlightened world. So I want to finish by saying that diversity, inclusiveness and intersectionality are critical principles that we need to encourage, support and embrace. Now, that's all I have time for today, so I welcome the opportunity to speak with you all, and I welcome any questions later. Thank you.
Thank you.